welcome to all. My name is Tanya Landon, and I will be co-chairing today's event together with Catherine Kunz and Christopher Boog. On behalf of the ASA and the Swiss Arbitration Centre, we are delighted to welcome you to celebrate the launch of Swiss arbitration.
During today's conference, you will first of all learn about Swiss arbitration. We will also be discussing Switzerland's rich history and bright future as a centre of excellence for international arbitration. We will then hear from the drafters of the 2021 Swiss rules and learn about their new features. Last but not least, you will also discover the Arbitration Toolbox by ASA and see it used in action.
Between the different panels, we will be showing short videos of friends of Swiss arbitration from around the world, and they'll share with us their experiences with arbitration in Switzerland.
The conference will be followed by 2 short networking sessions. We look forward to this opportunity to connect with you and bring together the Swiss arbitration community and its friends around the world.
So to kick off this conference, we have the great pleasure of handing over the floor to the new Executive Director of ASA and the Swiss Arbitration Centre, Corinne van Trotta, and also the President of ASA, Felix Dasser, and they'll tell you more about Swiss arbitration. So over to you, Corinne.
And a very warm welcome to the Swiss arbitration launch. I have joined ASA as the Executive Director in March this year, and since June, I'm also the Executive Director of the new Swiss Arbitration Centre. If you have followed the Swiss arbitration market over the last couple of months, you will have noticed a lot of news. There is the new Swiss Arbitration Centre, the revised rules, a new website, a new branding. Why all of these news? Well, around a year ago, I met a friend from the Swiss arbitration community in Berlin, where I lived and worked for the German Arbitration Institute. We chatted over an Indian lunch bowl, and I asked my friend, how does Switzerland position itself in the world of arbitration, and how does it work with these 2 institutions, ASA and SKY? My friend answered, well, it's complicated. It is not easy to understand for someone outside the Swiss arbitration community how these 2 organizations work together, who is doing what, and how it all fits. Even for me, being involved in both arbitration institutions, it is sometimes difficult to understand. So here we are, only 1 year later, I find myself in Switzerland, and since my arrival in spring, I have witnessed groundbreaking developments. I'm still amazed about the dedication and the efforts that the Swiss arbitration practitioners have put into place. And today is the day in which we would like to present to you the new setup, which will make the Swiss contribution to international arbitration and ADR easier to understand and use. Over to you, Felix, the mastermind behind the new setup.
Thank you, and a very warm welcome to all of you also from my side. It is a great honor and pleasure to present to you Swiss arbitration, to tell you what it is and how we got where we are today. But first of all, let's have a look at this nice Swiss landscape. You have hills, woods, meadows, a lake, and some mountains in the background, and yes, scattered villages, farms, and hamlets. Last week, this video has been presented to me as an option for the introduction, and I immediately was remembered of the Swiss arbitration landscape. It is attractive, idyllic, tidy, a bit bucolic maybe, and definitely a bit too scattered. That's also how the ASA board saw the Swiss arbitration landscape. And that's why we decided to put everything under one roof. And with this roof, one portal for everything that is Swiss arbitration. So that's how ASA created Swiss arbitration. This portal, it's new, it's modern, it is work in progress. There's still space under the roof, and this portal is designed to grow. Right now, we have 4 organizations that share the same branding under the umbrella of Swiss arbitration. We have the Swiss Arbitration Association, ASA, the think tank. We have the Swiss Arbitration Centre, or simply the Centre, for the administration of cases under the Swiss rules. We have the Swiss Arbitration Academy for education and training, and we have the Swiss Arbitration Hub for the organization of hearings. Sharing the same branding means close cooperation, means control of quality, means a common commitment to constantly improving the quality of the services for users of arbitration and mediation. This portal is, however, not just leading to these 4 organizations that share the same brand of Swiss arbitration, but it also contains links to other organizations. Now, if you miss your favorite organization here, please don't get angry. Get back to us. We are more than happy to add further links. Swiss arbitration is not just a portal for organizations, it's also a portal for information. The website provides easy access, for example, to the history of arbitration in Switzerland. Let's look at this. 1872. Here you see Geneva in 1872. Geneva is not just a city of peace by diplomacy where world leaders shake hands, as 2 of them did last week. It is also a city of peace by dispute settlement, where world leaders, and as well as business people, argue their case in front of international arbitrators. There's also information about why Switzerland is such an enduringly popular venue in arbitration. There's also information about Swiss arbitration law, including jurisprudence, everything available also in English. And there's information about another successful Swiss export product, Swiss contract law. In the last ASA Bulletin, I showed that in Swiss arbitration cases, all kinds of foreign substantive laws apply from all corners of the world. But in the very large majority of cases, it is Swiss contract law. And particularly also in cases where none of the parties has any obvious link to Switzerland. Now, spoiler alarm. Here you have a link to the Arbitration Toolbox by ASA. It's a great new online tool developed by an ASA task force that will benefit all arbitration users. You will hear more about it during this event. And here is an easy link to the popular ASA profiles, an indispensable source for reliable information about potential arbitrators. There is more, and there will be more over time. This portal is for you. Check it out and enjoy the benefits of Swiss arbitration. Thank you. And with that, over back to Catherine.
Thank you, Karina and Felix, for this great introduction to Swiss arbitration. We will now show our first short video before we meet again for our first panel.
Hi everyone, my name is Diana Kwiatkowski. Greetings from sunny Sydney in Australia. I lived in Geneva for nearly 8 years, initially to do the MIDS program and then working with Sidley Austin in their international arbitration group. It was at Sidley that I was lucky enough to receive my first 2 arbitrator appointments under the Swiss rules. The first appointment in particular was daunting and exciting in equal measure, but the Swiss rules are very user-friendly and clear, which means that the procedural aspects of an arbitration run smoothly, sort of like the very efficient Swiss train system, as I recall.
I've experienced arbitration in Geneva, Zurich, and Lausanne in Switzerland. I'm always impressed by the quality of arbitration proceedings in Switzerland. I'm particularly impressed by plenary view procedure and the very efficient control of cross-examination in Swiss arbitration. I loved it.
For me, Swiss arbitration is really the gold standard when it comes to no-nonsense, straightforward resolution of the parties' dispute, with co-arbitrators and arbitrators having a very good sense of the commercial needs of the parties and the stakeholders involved. And you can also see this spirit in the current Swiss rules. I had the pleasure and honor to be part of the review committee that looked at the recent changes of the Swiss rules. And you can see the atmosphere here. It's sort of more of the same of the spirit of the Swiss rules, but updated really to current needs of the parties. And little anecdote, it happens to me sometimes, actually not that rarely, that people ask me whether I am Swiss, and I always say there couldn't be any better compliment as an arbitrator.
Switzerland, from an Austrian perspective, the land of higher mountains, more luxurious watches, better chocolate, more punctual trains, and high quality international arbitration. Congratulations and keep up the good work.
After this short interlude, we are now back for our first panel, which will discuss the past, present, and future of Swiss arbitration. Now, this panel will be moderated by Anna-Maria Tamminen, a partner at Hannes Snellman, who works out of the firm's Finnish and Swedish offices as counsel and arbitrator. Anna-Maria not only has an international background and practice, she also has strong ties to Switzerland. And believe it or not, she was even raised in Valais. So Anna-Maria, this makes you ideally placed to take over from here and introduce the distinguished speakers of your panel.
Thank you very much, Catherine, for the kind introduction. And while my panelists don't really need an introduction, I have the pleasure of introducing to you Professor Pierre Tarcier, who has spent most of his professional career as a professor, mainly at the University of Fribourg in Switzerland, where he taught, among other fields, contract and torts. He has chaired the ICC court and is now working as an independent arbitrator, and he recently joined the law firm Peter & Kim, based in Geneva and Seoul, as senior counsel. I also have the privilege of presenting to you Gabrielle Natterbas, who's a partner at Hamburg in Zurich. With over 20 years of experience, she has acted as party counsel and arbitrator in numerous international arbitrations, both in commercial and investment proceedings. She has served as president of the Arbitration Court of Skye from 2016 to 2020. She's a board member of the ASA, a member of the LCA Court, co-chair of the ICAS Task Force on Damages in International Arbitration. She has recently received the Client Choice Award 2020 in Switzerland in arbitration and ADR. Now, with your permission, I will address you both on a first name basis from here on, as only a true Finnish person would. But I have a question to you both, and I'll let the ladies go first. So, Gabrielle, what's your favorite memory or moment or anecdote of Swiss arbitration that you would want to tell our audience?
Thank you, Anna-Maria, for this very kind introduction. It's very difficult for me to pick just one moment or one memory, but of course I have very vivid memories, in particular of my very young days as an arbitration practitioner, in particular at that time serving as a secretary. And that was also the case when I was pregnant. And I still remember that I was there pregnant at a hearing, and one of the participants referred to me constantly as the fourth and the fifth arbitrator. Of course, also has awarded me with a lot of nice memories. And I think one of the nicest memories I have, and of which I'm very proud, is that I had the pleasure and the privilege to found also below 40. I was very much inspired, having practiced in London and seeing there the young arbitration folks gathering together, joining forces with the young LCA, that when I returned to Switzerland, I found some very also enthusiastic practitioners who are ready and willing to start this new adventure with me. And nowadays there are so many young arbitration associations, and it just feels great having contributed part to such a development.
The rest is history. And so, Pierre, what would be your anecdote? I presume you haven't had a secret fifth arbitrator on the panel, but
I think taking the title of this event, past, present, and future, probably I represent for obvious reason the past. So if Gabrielle has so many souvenirs, I have, of course, quite a lot. I would like to take one, an old one, very old one. At Geneva had organized a meeting, and at this meeting, some very prominent Swiss arbitrators were present. Robert Briner, Jean-François Poudret, Pierre Lalive, and Claude Raymond. And I remember Claude Raymond saying to the audience of some hundreds arbitrators, I cannot imagine that an arbitrator can have more than 2 cases. What do you think about it? And everybody disappeared under its desk because, of course, it was a statement that was very impressive. But 2 lessons out of it, and it's important. The first is, of course, that arbitration has changed drastically in the method, it's clear. But on the other side, and I like it, it's the fact that it still remains a service, a very demanding service. It's not just a business. And the way Claude Raymond mentioned it, was a very good evidence that it is a fundamental activity for lawyers in particular.
having studied their books, I think it's clear that they all ended up having more than 2 cases in parallel. But we will first address, the session is entitled Past, Present, and Future. And why don't I start with the present? And I mean, what we heard from Felix Dasser just a moment ago, Switzerland has a history of over 100 years in arbitration. The Swiss Federal Supreme Court has set many precedents that are often quoted in arbitration cases. The Swiss seats rank at the top of internationally preferred seats when studied, for example, by White & Case in 2021. Switzerland is home to hundreds of full-time arbitration experts that you can find in the directory. Most of these people are thought leaders in their field, and so are the Swiss institutions. The Swiss universities are at the forefront of academic teaching. So Pierre, knowing all of this and the long-standing tradition of arbitration, which 3 factors, in your opinion, have contributed the most to the development of what Swiss arbitration is today?
Okay, there are certainly more than 3 factors, but indeed I will concentrate on 3 because also of my activity. I would say the law, the arbitrators, the judges. The law first, because Swiss law has some specificities that are unique or almost unique. And the way it has been developed, especially in arbitration, in the field of arbitration, is very telling for this evolution, for this specificity. It started with the cantons, and then the cantons decided to make a concord, a sort of treaty. And then you had the first part of international arbitration ruled in the pillar. And then now we have the domestic arbitration that is now ruled in the new Swiss Code of Civil Procedure. So an evolution that goes from the canton to a federal, to a national system. And this shows already the difference and the cultural side of Switzerland. Secondly, arbitrators, there is a long tradition. Felix, a moment ago, mentioned already the Alabama case, but there were a lot of cases with it in Switzerland. There is a long tradition with high reputed, high recognized arbitrators. I gave a few names a moment ago. And the third, you don't need only to have a good law, you don't need to have good arbitrators, but you must also make sure that there is a good control of the work done by the arbitrators. And I think that the Swiss Supreme Court in particular played a very important role in the high quality, in the control, but also in the high quality of the Swiss arbitration. The quality of the decision, the speed, only one step, by the way, and then the speed. Felix has always beautiful statistic that shows that the average for a case is 6 months, which is, of course, really an incredible advantage for arbitration. So far, my first answer.
So you say law arbitrators and then the judges who look after their work. Gabrielle, which three factors would you add to this list?
We definitely will not make it an exhaustive list. So it will just be two additional examples why Switzerland is where it is today. I would like to add neutrality, culture, and its innovative endeavors and achievements. Coming to neutrality, I think this is the first thing everybody ties to Switzerland. Switzerland offers a proven neutral and stable environment. There's a long-standing tradition in neutrality in international conflicts, and that makes it, of course, a very ideal venue for international dispute resolution. But also culture is important. Switzerland's culture is internationally oriented. It is a small country. It has historically depended on export. And that's why his culture, diplomacy, economy, and laws uniquely tune, of course, to the needs of international commerce, again, making it eligible and ideal for international arbitration. And last but not least, I would like to emphasize, it has been a first mover in adapting innovative instruments that then became the standard also for other arbitration rules. And I think I would like to mention just a few, and among those are, of course, its enactment of expedite proceedings in the Swiss rules in 2004. It was one of the first arbitration institutions who actually came up with this new invention, which has become the standard in almost all arbitration rules nowadays. I would also like to add that the Swiss Chambers Arbitration Institution was nominated by GAR for its very revolutionary new turbo arbitration clause, a tool that even allows to super expedite procedures. For those who have never tried it out, please try it out. It's fun, it's innovative, and it's definitely user-friendly and meets the request of the time to address cost sensitivity. Last but not least, you will hear today more about the Arbitration Toolbox, where I had the privilege, together with my partner colleague Stephanie Pister and senior associate Dilber de Wieler, to be crucial in the development. Also, that tool hopefully will place Switzerland in the pole position to provide arbitration-friendly services and preserves with that its reputation in the international arbitration community.
I'm sure that it will. Yeah, one thing we didn't mention is academia, and you have a long career in academia. What role has academia and academics played in forming Swiss arbitration to what it is?
I will start by saying that it took quite a long time to the law faculty to introduce classes on arbitration now. It is, of course, done and at a very good level. Beside that, you know that some special program have been now introduced in Switzerland. I would like to mention the MIDS, the Master of International Dispute Settlement in Geneva, and of course the Arbitration Academy. These are really excellent, by the best, the few best program that exist, and it is worldwide recognized. Now, this is one side, of course, the teaching, but another is the interest that the academics have taken in the development of arbitration law. There are a lot of books that have been published, and very famous books, which are still considered as standard books in arbitration. And thirdly, not least, is the fact that like in other countries, of course, but nevertheless, there were always a large number of professors sitting in arbitration tribunals, and still are. And I like this mixture, if I may say so, between people from the praxis and people from the theory, from the case law. So I think that there is a special interest in Switzerland for the arbitration and the arbitration theory.
And Gabrielle, from the perspective of a private practitioner, how have Swiss law firms and practitioners evolved to stay at the top of the profession now?
I think what I mentioned before, its culture is also reflected again in my answer to you. Switzerland offers a pool of lawyers who very often speak many languages and who very often have studied also abroad. This makes, in my view, Swiss law firms and its practitioners very eligible for international arbitration. They feel comfortable in a civil law, but are also, of course, not shy to practice in a common law environment. They have no problems in dealing with exotic jurisdictions and laws. And they can profit on top of Switzerland's long-lasting experience in arbitration. Last but not least, I always have to laugh if I attend international arbitration conferences. There are always huge delegations of Swiss practitioners there. This shows how eager they are to stay on top of arbitration developments, and they really and truly enjoy also being active in the organizations. And with that, of course, ensure that the Swiss arbitration community is present in the outside world and enjoys the excellent reputation.
And I'm sure with your central location and the breadth of people, that will stay that way also. Let's take a segue and talk a little bit about the future, the elements of success there. And I have a question to you, Pierre. You mentioned that one of the foundations of Swiss success is the law. What sets Switzerland apart in this field?
This is a subject that I like very much as a teacher because I like Swiss law. I used to teach Swiss law during decades. I'm not sure the best one in the world, it doesn't matter. I will not change it for another. Why? You may know that I was teacher in Fribourg, a very small city, bilingual city between the Swiss-German part and the French part. And Swiss law is exactly the evidence that it is possible to have this culture in the same law. What has been developed is an incredible, not only mixture, but open view of all cultures. And this makes this law very, very special. It is simple. It is written in a way that is very open, therefore extremely easy to adapt in international cases because it doesn't go into much details. It is just ready to be taken as a real basis for business development. And I like it, and I think it is extremely important and a good sign that now all institutions will come under the same roof, as Felix said a moment ago, because indeed this is one of the most important advantage of Swiss law. And it's not only the case for procedural law, arbitration law, but also for the law on the merit and for substantive law. Procedure is very much influenced by culture. And it has been possible to have a law that is really acceptable to all communities. And also the law itself, contract law, is very much influenced by the culture. And we have the German, of course, a strong German influence, but we have also French influence and other influences that have formed the Swiss law. So I think this is a very key element for the success of Swiss arbitration, if, of course, Switzerland is chosen as a seat and if Swiss law is chosen as a governing law.
And Gabrielle, you've been a board member of ASA and the president of the Arbitration Court of Sky. In your experience, what role do the arbitral organizations and institutions play in Switzerland?
In my view, they play a very important role. Also, and the Swiss Chambers Arbitration Institution have been crucial, in my view, to the fact that Switzerland and Swiss arbitration is perceived since decades as one of the most practical and user-friendly organizations, laws in the world. The enactment of the International Private Law Act, in my view, is a very good example to show that, because also and the Swiss Chambers of Arbitration Institutions were both, of course, very crucial in educating the Swiss Parliament what the current needs are and were up and ready to provide delegations who were following up so that the result was very much what the users expected in the community. They are, of course, both OSA and the Swiss or SCAI, also the Swiss Chamber Arbitration Institution, are, of course, also very crucial in having an active voice in the community and representing Switzerland. They both organize flagship seminars. The OSA Autumn Seminar is, of course, extremely well known and extremely well attended, but also the SCAI Innovation Conference has a really firm place in the agenda of the arbitration practitioners. They publish important papers such as the OSA Bulletin, the special series. And with that, of course, again, they contribute greatly to Switzerland's excellent reputation and its recognition in the arbitration world.
And so, in addition to the developments that are being celebrated here today, what do you expect to see on the institutional front going forward?
I'm very excited, I have to say, because as a president, I have gone through very different stages of SCAI. And it started with the harmonization of the secretariats. And it now culminates, of course, in the joining of forces between SCAI, the Swiss Arbitration Centre, and OSA. And I'm absolutely convinced that this is a very fruitful joint venture and will prompt increasing number of cases. On top, we have now a top product, the Swiss rules, which also is now again modernized, up to speed, and as such, it is one of the compelling reasons why you would go to Switzerland and choose Swiss-related arbitrations.
And yeah, you mentioned the Swiss supportive court system as one of the reasons behind Switzerland's ability to stay an attractive seat. What Swiss rulings, in your view, have most contributed to Swiss arbitration, and why is that?
I think I mentioned already a certain number of elements, and Gabrielle gave also some very good reason why arbitration and international arbitration in particular is so successful in Switzerland. I think there are also, I mentioned the quality of the law, but the quality of the law in a certain way also influence the style of the lawyers, be it the counsel or the arbitrators. We are formed and educated in a frame that is rather simple, open, ready, and able also to have practical solution. This makes, I think, a really good advantage in Switzerland. And again, sorry for repeating myself, but the fact that our Supreme Court is able to render a final decision within such a short time frame show that everybody participate, contribute to this style, Swiss style of arbitration. And you know that speed, quality too, but speed also is one of the key elements. And this also influences the way the practitioner, be it again counsel or arbitrators, are dealing with the cases. I think this is for me an important value that I can really mention after having seen, especially at the ICC, so many different styles.
Gabrielle, you've seen your clients come back to Switzerland with their arbitrations over the years, in your over 20 years in practice. What do you think Switzerland needs to do to remain an attractive seat and face off competition from, say, the Asian seats that are rising in the rankings of preferred seats?
I mean, the answer is easy, a simple one, and in practice, of course, hard to preserve. And that is that it should preserve all its top selling propositions that we have addressed at the beginning of this session. So it should stay and remain a neutral and stable country. It should stay user and arbitration friendly. And on top, what Pierre has just said is also important. It must keep up its efficiency reputation, and with that also its cost sensitiveness, because time is money. And that was one of our very important selling proposition in the Swiss rules. I think in terms of service friendliness and reasons why clients should come back, Switzerland has positioned itself with the new Swiss rules revision, but also with the revision of the PILA, the Private International Law Act, very well for the future. These revisions have brought up some important modernizations, but they have not compromised on these selling propositions. To the contrary, as Pierre just has also mentioned, I think one of the most important advantages of Switzerland, in particular Switzerland as a seat of arbitration, is that it has only one stage of appeal and that the Swiss Federal Tribunal is very fast in rendering its decisions. This is preserved, such as many other advantages we see in the Swiss rules. And on top of that, we have important modernizations introduced that allow, for example, online arbitration management, that address cybersecurity, all topics that in nowadays arbitration world are very important and should not be missed out.
We started by discussing the past and came to discussing sort of the factors that have Switzerland taken Switzerland where it is, discussed where we are today. If we now turn our gaze towards the future, Pierre, as a professor, you've seen many generations of arbitration lawyers study, graduate, plead before you, and then become your colleagues on tribunals or secretaries at least or counsel. Knowing what you know, how would you describe the upcoming generation of Swiss arbitration practitioners and arbitrators?
Of course, the question is quite a large question, depending who is speaking what. The new generation clearly is better prepared from a theoretical point of view, clearly, than we were. I've never had a club, or I had just a few hours during my studies concerning arbitration. Now, there are really good basis and good classes. I like the words of an old Swiss pedagogue who said we must form the head, the hand, and the heart. I like it. The head, this is for the university, for the program. The hand is for the practitioner, for the law firms, for arbitrators taking assistant of or secretary. And there is a lot to learn in order to have the skill that is necessary. I like also the third one, the heart, is to say we have also to keep in mind that this service that we are rendering is so important. So I think the new generation is very well armed in order to make really a good career, also knowing more and more languages. This is important, being more and more open to other culture, to business as such, also concerning the technical means that are not and will certainly in the future play a greater role. So I think this generation in Switzerland, like I agree elsewhere too, is really well formed and well prepared to the future.
That fares well for the Swiss arbitration community going forward. Gabrielle, I'll ask a question about the future from a slightly different perspective. You've been instrumental in developing new tools and embracing new technologies in arbitration, both as a practitioner and from an institutional driver perspective. We've all lived this digital life, whether we like it or not, for the past year. Which developments do you think are here today, and what would you recommend that arbitral institutions and practitioners do about them?
So for me, it's clear, I strongly believe that online management of arbitration proceedings, including virtual hearings, are here to stay, and this even way past the COVID era. This is simply because it meets the demand of the users. Many of those have detected that, in particular for smaller arbitration, cost-sensitive ones, this is an excellent tool, it serves their purposes, and that there is no, let's say, urgent need for physical hearings in many cases. But also for complex arbitrations covering witnesses, experts from various jurisdictions, virtual hearings also offer many advantages. With the increase of online management of arbitration, virtual hearings, etc., online tools become more and more important. Everything wants to be found on the internet. And with that, of course, I have just mentioned before, cybersecurity becomes an important topic that must be, of course, be put on the watch list of every arbitration institution. So institutions, in my view, have to adapt to these new trends and possibilities, and they have to adapt their rules so that they can provide and meet these new demands of the community. And also the practitioners and arbitrators must embrace the new technology possibilities. For me, the arbitrator of tomorrow must be able to offer services that can be done also online, must be able to organize virtual hearings and feel very comfortable in using all these tools. It will also be a chance for many arbitrators and practitioners because, in my view, this leads to even more internationalization of arbitration. It will play less and less an important role where a specific practitioner has its practice, where its law firm is seated, etc. And this is, in my view, a chance that we should all grab and further develop, and where we should not shy away, but see its advantages and deal with its risks.
That, I think, is a very good message to hear in the wake of what we've all been through for the past year and a half, working the online life that we have. To end this session, I have a few quick questions for both of you that go to your thinking about the future of arbitration in Switzerland, and then we can all discuss these at future conferences as to whether you were right or wrong. Favorite hearing venue in Switzerland and why? Quick answer from Pierre.
I cannot say that I prefer one of them. On the contrary, I'm happy to have two places, almost two places, like in other, not like in other countries where you have everything that is centralized. And again, it is really an offer made to the practitioner, to the business world. I will not decide on one side or for one side or for the other.
And Gabrielle, are you going to tell me it's your office because it's the online hearing?
No, definitely not. I go with Pierre. I think choose a nice place because Switzerland is small enough, easy accessible from international airports, wherever you decide and choose to have your arbitration. And I would also say, even if you go to the Valais, remote places, they are also up to date, can offer virtual hearings if you decide to be there or have a hybrid version of the hearing. So I also share Pierre's view. There is no favorite or most eligible arbitration place. You should go wherever you think the arbitration can be held in the most efficient manner. And let's not forget, it is also often nice to have social gatherings with your co-arbitrators or as a counsel, even if you are stressed with your parties, it's nice to be in a nice environment, and Switzerland has plenty of nice environments to offer.
Sounds good. So I think that it's not all going to be virtual here. There's still hope for the physical hearings. Most prevalent type of dispute in Swiss arbitration in the future. What would you say to that, Pierre?
I don't know. Really, Switzerland is, and Swiss arbitration world is open to all possible sort of type of dispute. I do not think that there will be a specialization. We see now also more and more investment cases with suit in Switzerland. So I think it's really, you're trying to force us to make choices. I refuse to make choices because I consider we have an open system, and it is really ready to accept all types of disputes.
And Gabrielle, is there a trend that you think that we will see some type of dispute, or do you agree with Pierre?
I totally agree with Pierre. And I mean, if you see some trends, then they are short-term trends. Of course, nowadays with COVID, a lot of firms are suffering. More agreements are easily breached because of lack of financing possibilities, etc. But that's a short-term development. In the long run, I share Pierre's view. I think Swiss arbitration is eligible for all types of arbitration, and there is not one specific industry area or one specific area of law for which it is more eligible or more ideal.
Now I will let you paint a broad picture, as broad as you want. Where do you see Swiss arbitration in 50 years' time? What would you say to that? Yeah.
I think the question should be asked to Gabrielle. She has more chances to be there in 50 years. I doubt that I will be there. In any case, the answer is, of course, extremely difficult because things are changing so rapidly. We are now, what we are, and Gabrielle mentioned it so wisely, what happened in the 2 last years is really an incredible evolution, and the arbitration world was able to adapt to this. What it will be in 5 years already, Anna Maria, I would really be happy to know. In 50 years, okay, let's wait.
And Gabrielle, is it going to be same or different?
So one thing is clear, Swiss arbitration will still be there and will still have a very dominant role to play. And I must say, I'm an optimist, I'm an enthusiastic person, and I live and dream on, and I dream of this joint venture that we have now started to be extremely successful. I'm confident also that we will be successful, and with these new possibilities and synergies that derive therefrom, we can even promote Swiss arbitration more intensively. And with that, definitely the success and increasing number of cases must come, because again, there is nothing that would prevent us from being successful. We have an excellent product. We have a court which is unique in its way, because it actually consists of very experienced arbitration practitioners, all volunteering, all spending their free time just to develop Swiss arbitration practice and make sure that the arbitration cases are handled best under the Swiss rules. I mean, this is unseen. And on top, we have a very active community and a lot of cultural and historical advantages to offer. All this combination will make sure that Switzerland in 50 years is still here, plays a dominant role, and I'm sure it can even overtake over some other classical or traditional arbitration jurisdictions.
And now I look forward to the discussion in 50 years' time when I will be 90. I can attend at least a virtual session, so I have something to look forward to. One very last question, I think this goes to, you can put in all your experience and all your heart and head, and what would be your top tip to the arbitrators of tomorrow?
I think I would, sorry for repeating myself, but I'm old enough to have the right to repeat. Again, what I said in connection with Claude Raymond's statement, do not forget that arbitration is not only a business, but it is a high demanding service. And I think it belongs also to the reputation of Switzerland and the Swiss arbitration to have this side in view and to pursue what has been done until now. In the future, I trust the new generation that I will be able to do that.
A very good tip. And Gabrielle, what would you say?
I really share Pierre's view. Such services need to be provided in a skillful, diligent, user-friendly, and cost-sensitive manner. But for me also, the arbitrator of tomorrow, as I have stated, must not only stay on top of arbitration development, but it must also stay on top of the technical development. I'm absolutely convinced that we see many further technical IT innovation coming and being used in arbitration. And as such, I'm convinced that an arbitrator of tomorrow must also be on top of these developments and must be able to use and exploit respective new tools.
Thank you, Pierre and Gabrielle, for this journey from the past to the present and these thoughts on the future of Swiss arbitration. I thank all the listeners very much, and over to you in Geneva.
Thank you very much, Amalia.
Thank you.
Thank you very much, Gabrielle, Pierre, and Anna Maria, for this very interesting discussion, and I might even say inspiring discussion on the history and future of Swiss arbitration. We'll be back for the second panel in just a moment after we watch another short video.
Hello from Canada. I'm delighted to support the launch of the new Swiss arbitration concept under the leadership of the ASA. I was fortunate to study international arbitration at the HEI in Geneva with Professor Pierre Lalive, and serve as a rapporteur at the Lausanne ICA Congress in 1983, devoted to the model law. After my Swiss introduction to international arbitration, I returned to Canada to spread the word and participate in the adoption of the New York Convention and the model law here. I'm grateful for my Swiss introduction to arbitration and the important role Swiss practitioners and academics have played in the development of international arbitration.
Switzerland and its economy are a success story. Important factors are an advantageous legislation and a common sense judiciary. This helps explain why Switzerland is world famous for as arbitration venue. We at Economy Suisse, the organization of the Swiss commercial enterprises, welcome efficient dispute settlement in Switzerland.
For me, sitting in Switzerland is as seamless an experience as sitting in my own home country in France. Everything is predictable and works flawlessly. Hearings organized in Geneva, Lausanne, or Zurich are always perfectly organized. And there's a rich arbitration scholarship in Switzerland, prompted in particular by the Swiss Arbitration Association. The federal law and international private law covers comprehensively international arbitration, and I'm a big fan of Article 182, Section 2, which permits an arbitrator to proceed ahead on the basis of efficiency and integrity. The case law of the Swiss Federal Supreme Court is stable and takes no one by surprise. What more can an international arbitrator hope for?
For me, Switzerland is basically the home of international arbitration, and my knowledge takes its roots there. Speaking about specifics of Swiss regulations, it was rather unusual to learn about criminal liability for false testimony in arbitration, something which tells you about the level of support and respect that arbitration enjoys in the state. Overall, I think that Swiss law is very promising for application globally, including in Russia-related cases.
And now for our second panel, we have the pleasure of hearing from some of the drafters of the revised 2021 Swiss rules. This panel will be moderated by Corinna von Trotta, who you met earlier today. Corinna, the floor is yours.
Thank you, Tanya. And welcome to the second panel, in which we will discuss the most important features of the revised Swiss rules of international arbitration. Let me first introduce to you the three speakers of this panel. First, to my right, we have Andrea Meyer. She is partner with Walder Wies in Zurich, with special focus on disputes relating to large industrial and infrastructure projects. She is vice president of the Swiss Arbitration Association. She is also a member of the Arbitration Court of the new Swiss Arbitration Centre, and she was also a member of the revision committee for the revision of the Swiss rules. Second, we are connected with Almut Vorndran. She is Senior Legal Counsel at RWE Renewables GmbH in Essen. The focus of her work is on the construction and operation of onshore and offshore wind farm projects in Europe and on dispute resolution. She is a member of the ASA User Council, which was consulted by the revision committee. Third, on my left, we have with us Jean Magarat, a partner with Frorieb in Geneva. He's experienced in international arbitration in all sorts of and a wide range of sectors and familiar with many arbitration institutions. He's co-head of the ASA group in Geneva and also a member of the revision committee. My first question goes to Andrea. What was the goal of the revision?
Well, thank you, Corinna. When this project started last summer, we had the reorganization ahead of us. SCAI was to become the Swiss Arbitration Centre. And we really wanted to use this opportunity to make a detailed review of the Swiss rules and explore where changes were necessary. And for that purpose, the revision committee took into account past practical experience with the rules, the suggestions we received from users that we consulted, and of course, recent international developments. Now, as for the resulting changes, I have grouped them into 5 main areas. First, we now have refined provisions on multi-party and multi-contract arbitration, and we will get back to that later in the discussion. Second, the rules contain responses to technological developments. The parties can now opt for paperless filing of the notice of arbitration and the answer. And the tribunal may decide to hold hearings remotely after consulting with the parties. And furthermore, at the initial conference, the tribunal and the parties are to discuss data protection and cybersecurity to the extent needed. Third, the role of the institution has been strengthened. This means that all deposits will now be held by the Secretariat, and there is no longer the possibility for deposits to be held by the Tribunal. It also means that the Secretariat is now to receive electronic copies of all communications. And finally, awards will now be notified by the Secretariat and no longer by the Tribunal, except for emergency arbitration. Fourth, changes have also been made in the area of independence and impartiality. Requirements of disclosure of arbitrators have been clarified and adjusted to modern arbitration practice. And there is now also the possibility for an arbitral tribunal to oppose the appointment of a new representative, where this would risk jeopardizing the impartiality or independence of the arbitral tribunal. And fifth, last but not least, amendments were made to further promote efficiency. This means that as soon as practicable, the tribunal shall hold an initial conference with the parties and prepare a procedural timetable. And now, this is quite interesting, the timetable is not only to include the time limits for the parties, but it is also to give an estimate of the time required by the tribunal for its main decisions. There is also an express provision inviting the tribunal to take into account, when allocating the costs, whether a party contributed to the efficient conduct of the proceedings and the avoidance of unnecessary costs and delays. And finally, a new provision emphasizes that the parties may at any time during the proceedings agree to resolve their dispute by mediation or other forms of alternative dispute resolution. There were also a number of changes regarding costs, but this will be further explored by my colleague Jean Marguerat.
Thank you, Andrea. So my question goes to Jean. What was the particular focus when revising the cost schedule?
Yes, the focus was to adjust the cost schedule to ensure the financial sustainability of the institution without making the whole process more expensive for the parties. And we had and wanted in particular to take into account an economic factor, which is the particular strength of the Swiss franc compared to other major currency like the euro or the US dollars. So we wanted to secure the competitiveness of the Swiss rules. And in order to do that, we compared the cost schedules of other institutions, including the major one and European one like the ICC, the Stockholm Chamber of Commerce, and the Vienna International Arbitration Centre. So we established the fee schedule and cost schedule in comparison with other institutions as well. We also wanted to make sure that the arbitrators are adequately paid. So there was a very small reduction in the arbitrators' fees, but here always with some flexibility to take into account the particular circumstances of a case, and then the court can readjust. We also were able to give more resources to the new center in view of its increased role by making a slight progression of the administrative costs. They remain very reasonable compared to other institutions. So there are no costs, administrative costs, until an amount in dispute of 300,000 Swiss francs. And the maximal administrative costs are of 75,000 Swiss francs. And this is for amounts in dispute in excess of 250,000 million. We also increased the cost in case of multi-party arbitration, and it can go up to 30% more than the normal costs. And we also included some extra charges to take into account extra work which has to be done by either the Secretariat or the court, and I refer, for example, for challenge or removal of an arbitrator, cases which remain in abeyance, certified copies of awards, and all these tasks which require extra work from the institution.
Thank you, Jean. Now my question goes to Almut. What is your experience with the Swiss rules, and why would you use them, particularly after the revision?
First of all, my experience, and this is confirmed by what I have heard from other in-house legal counsel, is good. The Swiss Chambers rules are clear, they are concise, and the support which the Swiss Chambers Arbitration Institution has been given in the past is reliable and efficient. As to the decision on choosing the Swiss rules, let me mention that we at RWE Renewables do a lot of energy projects, often with partners, always involving many contractors and suppliers. So our decision on which rules to take is not governed exclusively by what we would like, but very importantly, what is acceptable to our partners, contractors and suppliers. And I can confirm from my practice that the Swiss rules are perceived as one of the leading arbitration institutions in the world. For us, a globally active German energy group, it's a true alternative to other leading arbitration institutions. For continental European contracts and potential disputes in connection with them, we prefer a continental European dispute resolution, and here the Swiss rules come into play. The famous Swiss neutrality might also help occasionally to convince contract partners. And as regards the new Swiss rules, I think that the cost neutrality that the drafting committee has tried to maintain will be helpful, because usually what sometimes is raised is the question of, oh, Swiss arbitration, that's costly. And I really appreciate that this topic has been taken up in this revision.
Okay, sorry for this little interruption. Almut was actually at her last point wanting to mention that she was a great fan of the changes regarding multi-party and multi-contract provisions. And that's why I wanted to ask Andrea in the next step, what are the main changes with regard to multi-party and multi-contract provisions in a nutshell?
Thank you, Corinna, and I'm happy to pick up here. So most importantly, there is a new article, Article 5, which provides for a gatekeeping.
Ideas have been taken up.
Tess, I will continue for the moment, if Almut forgives me. So we have a gatekeeping test for multi-contract claims. This means that where claims are made on the more than one arbitration agreement, the arbitration will proceed unless the court determines that the arbitration agreements are manifestly incompatible. Now, one should note that this is only an entrance test, which, if passed, allows claims to proceed before the tribunal. However, the Arbitral Tribunal retains the power to rule on any objections regarding the issue of whether claims may be determined together. Now, it is for the Arbitral Tribunal to determine the appropriate criteria. They are not defined in the rules, but usually tribunals will seek to establish whether there was express or implied consent given the consensual nature of arbitration. The revised rules also contain more detailed provisions on cross-claims, joinder, and intervention. That is situations where, for instance, a respondent raises a claim against another co-respondent or joins an additional party, or where an additional party seeks to intervene in the proceedings by raising its own claims against an existing party. While all of this was already possible under the old rules, the new provisions provide more guidance regarding the process as such and the role of the institution. As a result, it is now stated in the new Article 6 that cross-claims, joinder and intervention require the submission of a separate notice of claim. Before the constitution of the tribunal, the notice is to be submitted to the Secretariat. After constitution of the tribunal, cross-claims, joinder and intervention are still possible in principle, if allowed by the tribunal, which has to consult the parties and take into account all circumstances. Now, in practice, in view of the parties' right to participate in the constitution of the tribunal, the joining of an additional party at this stage will normally only be possible if that party accepts the tribunal as constituted. Finally, the rules in Article 6.4 now expressly refer to the possibility of a third person participating in a capacity other than an additional party, again subject to the tribunal's permission. Now, this refers to the possibility of a third person participating which is neither a claimant nor a respondent, but intervenes in support of one of the parties. Many of us will know this form of participation from state court proceedings. In German, we call it Nebenintervention, in French, Intervention accessoire. The third person may wish to intervene upon its own initiative or because of a third-party notice, in German, Streitverkündung. With such notice, the respondent requests the participation of the third person in order to extend the effect of the award to that person. Now, the goal is for the Swiss rules to leave room in appropriate and limited circumstances for this form of participation. The tribunal will have to consider all circumstances, including the consensual nature of arbitration. So that's the changes in a nutshell. It's, of course, a very interesting and fascinating topic, but that's for another time.
Thank you, Andrea. Back to you, Jean. As mentioned earlier by Andrea, one of the goals was to make the arbitration proceedings under the rules more efficient. What kind of changes has been done in this respect?
Yes, so I would refer to two types of changes in order to reach more efficiency. The first kind of change is a more formal or administrative type of change, and the second one is a change in the process. I will first refer to the first category, and here changes of a formal or administrative nature include an adaptation to a digital world. And I think Gabrielle referred before to the more technology in arbitration, and I'm quite sure that it is the way forward. And it's already a reality, and we've seen that with COVID especially. So now we have electronic filings, we have remote hearings, which are specifically referred to in the new rules, and I think it's a good adaptation to this new reality. We also decided to eliminate the reference to outdated technology, and I refer, for example, to the telefax and to hard copies that you can dispense in many cases. And there is also an increased administrative assistance by the Secretariat, which will make the whole process more efficient. And I refer to, for example, the administration of deposits by the Secretariat and to the notification of awards by the Secretariat. So we make sure here that the proceedings are streamlined and efficient. Now I will move to the second category, which is the changes in the process. And Andrea referred before to some of these changes, which are reflected, most of them, in Article 19 of the rules. You have the initial conference to discuss with the parties the organization of the proceedings. You have the preparation of a procedural timetable, which must include an estimate of the time required by the tribunal for its main decisions. You have a reference to future organizational conferences to ensure an efficient case management. And You have as well a specific reference to both settlement and mediation, which, as we all know, can lead, if successful, to a very efficient settlement of the dispute. Efficiency is also considered in the allocation of costs, as it is taken into account if a party contributed to an efficient conduct of the proceedings and avoided unnecessary costs and delays.
Thank you, Jean. And good to have you back, Almut. For users, independence and impartiality of arbitrators are very important issues, as well as transparency of the arbitral process. Has the revision moved these matters forward?
Yes, I think that the revision process has brought improvements on a number of points. Independence and impartiality of the arbitrators are a basic requirement for arbitration proceedings, and the awareness of this necessity has increased over the past 20 years. I'm going to mention 4 points, and I hope that the internet connection will allow me to finish them. First point is a necessary update that has been done. On the point of disclosure of any circumstances which could give rise to doubts as to independence or impartiality, the rules had not been really clear in respect of the time period until appointment of an arbitrator. They could be read to mean that until appointment of an arbitrator, any facts which the prospective arbitrator might see as problematic would have to be disclosed only to the designating party, but not necessarily to the other side. The revised rules now provide for any prospective arbitrator to disclose any such circumstances to the Secretariat, which will forward this to the parties for comment. Second point, many users have expressed the wish for more transparency in respect of decisions by the court on challenges of an arbitrator. This is important, as in case of rejection of the challenge, the challenging party has to continue the arbitration proceeding with this arbitral tribunal. In this case, it is helpful if the challenging party is given at least a chance to know the considerations of the court. Until now, the rules provided that the decision by the court would not have to be communicated. We have brought this aspect during the revision process, and the sentence has now been deleted, so that we expect that in future the court will communicate reasons with this decision. We would also hope that information as to which members of the court have taken this decision will be included, but I understand that this might be not something that is achievable in the very near future. My third point touches upon the aspect of nationality. Many users wish that the rules also address this topic. The topic of the nationality of a sole arbitrator or of the presiding arbitrator in an arbitral tribunal composed of 3 arbitrators. I think the general opinion is that he or she should not have the same nationality as the parties. The drafting committee has taken notice of this point, but decided to deal with this issue in a practice note, where it intends to set out the practice of the court on this point. Last but not least, let me turn to Article 27, which now clearly states that any hearing may be held remotely by video conferencing or other appropriate means, as decided by the tribunal upon consultation of the parties. This is understandable, as requesting agreement by the parties to a proceeding would mean that in times of a pandemic, which you just experienced, justice might otherwise come to a complete stop. However, many users are requesting that, absent such exceptional circumstances, remote hearings should be used with extreme care by the tribunals. In particular, for evidentiary hearings, it should be carefully evaluated whether they are indeed appropriate. In this regard, we welcome that the drafting committee will take care to lay down in a practice note criteria to be considered by the tribunals. And I'm confident that the drafting committee will find an adequate compromise between efficiency and interests of the users.
Thank you, Almut. We got to the end of your answer. That is very good. Now we are going to have a last round of questions with short answers. The first question goes to Jean. What is the key difference and the unique selling point of the revised Swiss rules in comparison with other rules of important arbitral institutions?
So I think, Corinna, that the Swiss rule represents the right balance between trust in the arbitrator, which is at the very core of the Swiss rules, and a light but efficient administration. This is, for me, the DNA of the Swiss rules. So you have a wide discretion to the arbitrators, but at the same time, with a safety net of a solid body of rules and with a very solid institution with the case administration committees and the special committee. The Swiss rules have always been at the forefront of efficiency as well. We have seen that, and Gabrielle referred to that before, when she reminded us that the Swiss rules pioneered the expedited procedure in 2004. We've seen that it has been imitated now with success with other institutions, and we know that many cases of the Swiss rules are effectively and very well administered by the way of the expedited procedure. We know also that the Swiss rules have adopted in 2012 the emergency relief procedure, which is also a very powerful and efficient tool in certain circumstances at the disposal of the parties. And we see now with the revised rules that the Swiss rules always want to be at the top of efficiency and also to be modern and at the top of technology. Also, and it's also part of the DNA of the Swiss rules, there is always flexibility and efficiency in the process. For example, you have no terms of reference, which can sometimes delay proceedings, and you have simply a procedural timetable, which is a very efficient tool. You have no scrutiny of the award, which, as we know, can also take a lot of time, and we have a scrutiny of the award limited on costs, which is protective of the parties which know that they will not have exaggerated costs for their arbitration. So always flexibility, efficiency. And last but not least, we have a specific provision which provides for a high degree of confidentiality, and I personally think that it is a comparative advantage.
Almut, the rules of SKY and now the Center are called Swiss rules. Is there anything particularly Swiss in the way arbitration is done under the revised Swiss rules?
Well, I think two things are worth mentioning here without falling into the trap of using cliches like Swiss chocolate or the famous quality of Swiss clocks. First, I think the reliability and predictability of the work of the institution should be mentioned. As a user, I know what I get, and that is also the reason why I can accept the high degree of flexibility which has been built into the Swiss rules. The reason for this is that there are many excellent and very experienced arbitration specialists supporting this institution, and they stand for pragmatic, reasonable, prudent, and well-founded decisions. Secondly, the organization disposes of a certain pride in a positive sense, which makes it somewhat immune against trying too many new things too quickly. Following every new trend might put at stake the good reputation as a well-established arbitration institution. And so I think one example here is the respect of the importance of confidentiality. This has been kept during the last revision process, respects the user's interest, and should be mentioned here.
Thank you, Ahmed. Last question goes to Andrea. Where do you see the Swiss rules in 5 years from now?
Well, on a personal note, I hope we don't need another revision in 5 years after all the work that we put into this. But aside from that, and more importantly, I expect the rules to be used even more frequently and more globally. They really deserve it because the rules are modern, they're easy to use, and they're flexible. But as Almut just said, it's not only about the rules, but also about the institution which administers the rules. And the combined advantages of the center and the rules are compelling. What they offer is a real Swiss product. Users get high quality, efficient and reliable service in an extremely arbitration-friendly environment that is internationally minded and neutral. And finally, the center just experienced a further boost due to the closer cooperation with ASA, which has become the majority shareholder. And I truly believe that this joining of forces within the Swiss arbitration market has been a crucial step to the continued success of Swiss arbitration. So I feel this is a great opportunity for users globally to benefit from the qualities that Swiss arbitration has to offer.
Thank you, Andrea. Thank you, Almut. And thank you, Jean. This was a great pleasure to have you on this panel. And we are going back to Catherine.
This was a very helpful overview of the new features of the 2021 Swiss rules. So thank you very much again, Almut, Andrea, Jean, and Corinna, not only for your excellent presentation today, but also and more importantly for your contributions to the revision of the Swiss rules, which, as we have heard, has made them even more cost and time efficient. Now we will be back for our last panel after another short video.
Hello, this is Anecdote from Turkey. My experience with Swiss arbitration goes back 20 years. I remember one day I received a call from the Swiss chambers telling me that they felt the need to translate their rules into Turkish because of the high demand from Turkey. This, among various other reasons, shows that the Swiss chambers truly cares and values its users. In that regard, Swiss Arbitration Association's contribution through numerous initiatives is undeniable and applaudable. Switzerland has a well-deserved reputation for its strong pro-arbitration policy, and I'm happy to be called as one of the friends of Swiss arbitration. Thank you.
My name is Michael Huang. Formerly, I was Singapore's ambassador to Switzerland, and I now practice as an independent arbitrator. Let me give you 3 reasons why I like international arbitration in Switzerland. First, there is widespread knowledge of international arbitration among the Swiss bar, and parties can select from a wide array of well-qualified arbitration practitioners in selecting both counsel as well as arbitrators. Next, there is also excellent knowledge of international arbitration in the Swiss judiciary, whose judgments are internationally respected. One further advantage is that all setting aside applications go directly to the highest court, the Swiss Federal Court. So there will only be one opportunity to set aside an award, and that speeds up the ultimate enforcement process. Finally, access to knowledge of Swiss arbitration law for foreigners is easy. Apart from having materials in the national languages of Switzerland, there are also several excellent textbooks on Swiss arbitration law and practice in English. So what is there not to like and admire in Swiss arbitration?
The Swiss brand is highly sought after globally, particularly in service industry, including arbitrator services. ASA has been highly respected in international arbitration community because it has offered valuable insight and visions for years. I'm so excited to hear that ASA, together with Swiss Chamber of Commerce, has launched Swiss Arbitration Centre. I'm so confident that Swiss Arbitration Centre will show the model of efficient and effective international arbitration practice. Congratulations to Swiss Arbitration Centre.
Now, we are all excited to finally discover the Arbitration Toolbox by ASA. Our third and last panel will tell you all about the toolbox and even give you a live demo. This panel will be moderated by Elliot Geisinger, ASA's former president, and it is Elliot who first came up with the idea of the toolbox. Elliot is a partner at Schellenberg Wittmer in Geneva and head of the firm's international arbitration practice. I will now leave the floor to Elliot, who will introduce the other panelists.
Thank you, Catherine. And thank you for having very generously attributed to me the paternity of the toolbox. I should say that, like all good ideas, the ASA Arbitration Toolbox has many parents, and many people contributed to this over a considerable span of time. But the idea, let's come back to the idea at the beginning. It was percolating around the same time as the revision to the Arbitral Notes on Organizing Arbitration Proceedings, and also at the same time that ASA was taking positions, sometimes controversial positions, on the IBA guidelines on party representation and more generally on the uniformization or standardization of arbitral practice. I recall in particular a discussion I had with Michael Schneider. We were on the train somewhere between Geneva and Zurich, and we were bouncing ideas off each other, and we were thinking, how is the best way to point to diversity in arbitration? The fact that for every question that may arise, there are always several ways of dealing with it. There's not a single way. That's the key. That was really the key for us. How could we do this in a way that is not prescriptive, like the Arbitral Notes, and how to do it in a way that is not standardized? So behind the toolbox, like I said, there is this idea that for any issue that may arrive in international arbitration, that may arise in the proceedings, there's not one single one-size-fits-all way of dealing with them, but many ways. And of course, then, we also had the additional challenge of how to do this, how to create a helpful tool for practitioners that would be electronic and digital. That's how the idea came into being. Perhaps that was the initial thought process. Since then, like I said, there have been others who have parented the project. The project has evolved, has morphed considerably over time. But what has stayed always was the idea that we had to promote diversity and to not take a non-prescriptive approach. And I should say that this has earned the ASA Arbitration Toolbox the official support of Arbitral. We are one of the very few private organizations to have achieved this. Many people have contributed to this, not least members of the panel today, also Gabrielle Natterbas. These people will be named by Stephanie later, and I would like, however, to say a huge thanks to them. Now, enough history, enough generalities. It's time now to show the toolbox for what it has become, what it is. I've talked about the seed and the flower. Now let's see the flower. And we have two panelists. The first panelist on my left is Stefanie Pfisterer. She is a partner at Hamburger, where she practices international and domestic arbitration and also commercial litigation. Her resume, the list of her achievements and distinctions is too long for me to repeat now. I would refer you to the Hamburger website. Let's just say that she did her law degree in Bern in 2007, a Dr. Juris in Zurich in 2011. Somehow between the two, she found the time to be admitted to the Swiss bar in 2009. She then went to Harvard Law School, got an LLM in 2012, joined Hamburger in 2014, and this year became a partner, for which I congratulate her. Very importantly, Stephanie is one of the main architects of what the toolbox has become, what it eventually did turn into, and she is therefore an ideal speaker. The second speaker is Misha Chandna. She is currently at MIDS in Geneva, the Master of International Dispute Settlement course. She is, however, a seasoned practitioner. She graduated with honors at the National Law School of India at Bangalore in 2016, was admitted to the bar in Mumbai in 2017, where she practiced until today, practiced at a leading Indian law firm in commercial matters, commercial litigation, insolvency litigation, and securities litigation, among others. Her interest evidently has turned now to international arbitration, for we have the good fortune of having her here in Geneva at the MIDS. So, Stephanie, perhaps you would like to show us a little bit about what the Arbitration Toolbox really is.
Absolutely. Thank you very much, Elliot, for the nice introduction. We'll now look at the flower, which you have so nicely described. So what is the Toolbox? It's an electronic platform that provides advice to the user on the various stages of an international arbitration proceedings. I would like to highlight two features of the Toolbox. First, the Toolbox is an interactive tool. It provides information to the user depending on what input the user enters into the Toolbox. And it does so on the basis of questionnaires, which we'll show to you later on. The second feature is the Toolbox is very practical. We have included sample documents which can be downloaded from the Toolbox website, and we have also included some definitions to explain terms frequently used in arbitration, and also so-called red flags, which alert the user to issues that are critical and of big importance in an arbitration proceedings. That is now a bit theoretical, but before we look at the Toolbox, I would like to mention and thank those persons who have contributed to the Toolbox. The working group was composed of Sebastian Besson, Michele Potesta of Levi Kaufmann Kohler, Anke Sessler, Jakob Sattler of Skadden Arps, Yoshimi Ohara, Shota Toda of Nagashima, Ono Tsunematsu, Urs Weber-Stecher, Flavio Peter of Wenger Fili, Xavier Favre-Bull of Lenz Stählin, François Kaiser, Christina Rouvinet of Kellerhaus Garar, Chris Harris, George Schalfung of 3 Verulam Building, and the working group acted under the lead of Andrea Meyer of Walder Wies, whom you have heard before, Elliot Geisinger, Schellenberg Wittmer, and then my colleagues Gabrielle Natterbas, Dilbert de Vitre, Antonio Ardielli, and myself of Homburger. So what is the plan with the Toolbox? As Elliot has mentioned, we have received the support of Arbitral, and we will present the Toolbox again to Arbitral at its next commission meeting and at its next session in July to further define the cooperation between the Toolbox and Arbitral. And then we will spread the Toolbox all over the world and show the Toolbox to as many people as we can. Are you now ready for a live demonstration of the Toolbox? Misha, should we go ahead?
Yes, sure. I recently received my first appointment as an arbitrator, and we have a case management conference next week, and I would like to set an appropriate timetable. In particular, I want to make sure that the timetable takes into account the specificities of the case, and I was wondering if the Toolbox could help with that.
Yes, it does, Misha. So let's look at the Toolbox. You can see here an overview, and then we enter the step organization, and we click on the step 2-3, determining the procedural timetable. And you can see here, if we click on this little hand, we can see here some general information on what a procedural timetable in an arbitration is. I will not read that to you because I'm sure you already know that. So we click on continue, and then we come to the first question. I mentioned that the Toolbox is based on questionnaires. So you answer questions, and depending on the answers you give, you'll be provided then with information. So the first question here is whether the proceedings are expedited proceedings. Of course, if the proceedings are expedited proceedings, that has a huge impact on the timetable. Now, Misha, are your proceedings expedited proceedings?
No, even though this is my first appointment, the matter in dispute already exceeds the maximum threshold, so that is a no.
Lucky you. Then we click on no, and we come to the next question. The next question is, have the parties made a request for bifurcation? And if we click on this little magnifier symbol, you'll get some more information on what a request for bifurcation is, if that term is not familiar to you. Misha, do you know that? Have the parties made a request for bifurcation in your case?
They have not.
So we'll click no, and we'll get to the next question. Another question, of course, that has an impact on the timetable of an arbitration is whether the respondent has applied for security for costs.
The respondent at this point has some faith in the claimant, so no, not at this point.
So we click on no. The next question then is,
Is it clear how many rounds of written submissions the parties will require?
Yes, that's clear.
And we click on yes, and we'll get to information on providing dates for submissions in the procedural timetable. If it's clear on how many rounds of submissions there will be, of course, you can provide for that in the timetable. And we click on continue and come to the next question. The next question is it clear that there will be a hearing in your case, Misha?
Given the circumstances, it's a bit unclear at this point.
So we'll click on no. And the question is, should a hearing date nevertheless be set?
Not at this point.
So we click on no, and then you can find some information on fixing a partial procedural timetable, so not providing for a hearing date yet, but allocate or fix a hearing date later on. We click on continue. The next question then is, do the parties file their main evidence with their written submissions? That, of course, also has an impact on the procedural timetable. Is that the case in your arbitration?
Yes, that is.
So we click on yes, and then again, you can find some information on how to proceed if the evidence is filed together with the main submissions. Then we click on continue, and we'll get some further information on further issues to consider in a procedural timetable. One feature I have not mentioned so far are these words in red. These are defined terms, and if you hover over these terms, you'll get a definition so that even a user who does not know what document production stands for will know what it means. So we are then at the end of this questionnaire, and my question to you, Misha, has the toolbox given you some more input on how to fix a procedural timetable?
Definitely. I feel all prepared for my case management conference now.
Excellent.
Just one further question, Stephanie. I was wondering if the toolbox could also help counsels in cases. For instance, right now we are trying to find the right arbitrator for a case, and I was wondering if the toolbox could also help us with that.
Yes, the toolbox also includes information on how to select an arbitrator. That is contained in step 7 of commencement, finding the right arbitrator. The first question here is, should the members of the arbitral tribunal or the sole arbitrator possess certain qualifications? Of course, the parties can agree in the arbitration agreement or later on whether tribunal members should possess certain qualifications. Is that the case in your?
Yes, the parties do have certain qualifications they would want the arbitrators to have.
This is the information box that explains on what sort of information can be included in an arbitration agreement or later on. And then if we have clicked on yes, which we have done, then we will get to a red flag. The red flag specific qualifications, it alerts you that if you include too many requirements for an arbitrator person, you may limit the pool of available arbitrators. So just to be aware of that. We click on continue and come to the next question, which is, do the arbitration rules and/or arbitration law stipulate any specific qualifications that the members of the arbitral tribunal must meet? Some arbitration rules or arbitration laws do that, and of course you will need then to follow these requirements.
In our case, there are no such specific requirements.
And we click on no, and the next question is whether the arbitration rules and the arbitration law gives guidance on the requirements of independence and impartiality that the arbitrators must meet. Is that a case in your case, Misha?
No, they have the obligation, but no guidance on what the requirements are.
If that is not the case, then the general principles of general standards of independence and impartiality apply, and the toolbox gives you information on what these standards are. We click on continue. The next question is,
have the parties already identified the criteria that their arbitrator candidate should fulfill? So in a given dispute, when you need to select an arbitrator, obviously the question arises whether or what criteria that arbitrator should meet.
The parties at this point have not settled on the criteria that they would want implemented.
Then we click on No. And the toolbox gives you then some information on possible criteria you may want to include or you may want to select for your arbitrator. Obviously, that can be experience in arbitration, the arbitrator's language skills, or also the familiarity of an arbitrator with the law applicable to the case. And then click on Continue, and the question then reads, should the parties evaluate a potential arbitrator that they consider appointing?
Yes, they would like to evaluate.
And then we click on Yes, and you'll get some information on how you can evaluate a potential arbitrator candidate. You get information on the means to evaluate a potential arbitrator and how that arbitrator can be contacted. And that brings us to the next red flag, that is interviews with arbitrator candidates. That is a thorny issue in arbitration, whether interviews with arbitrator candidates are permissible and to what extent. So before you contact your arbitrator candidate, I suggest that you read the red flag here. And then we are at the end of this questionnaire. My question again to you, Misha, has the toolbox assisted you with selecting an arbitrator candidate?
Yes, thank you so much, Stephanie. This was very helpful, and I feel really prepared both for arbitrator and counsel engagements now. So thanks a lot.
Well, thank you to both of you. Stephanie, there was another question that arises sometimes in practice that I find as an arbitrator is sometimes thorny to deal with. It's when there are multiple experts in the proceedings. And I know that the toolbox contains something about that, and perhaps you could share with us what the toolbox has on that.
Sure, Elliot, with pleasure. That is, as you rightly pointed out, that is another thorny issue, the examination of multiple experts. We have included a step in the toolbox that deals with that issue. We will not go through that questionnaire now, but I suggest that you do that on your own later on. But the toolbox includes suggestions or information on how to deal with that. For example, on how to deal with or how to compose joint expert reports, list of disputed, undisputed issues, and then also how to examine multiple experts at the same time, experts conferencing at the hearing.
Well, thank you. Thank you, Misha. Thank you, Stephanie. I found this very illuminating, and I find it a very happy development after what was a very, very long road. Would also like to thank all of you for having listened, and you know whom you can get in touch with. If you have any questions about the Arbitration Toolbox, thank you very much.
To Stephanie, Misha, and Elliot for this great demonstration of the toolbox. You know, I have to admit, I've heard a lot about the toolbox myself, but I haven't actually seen it in action or used it before. And now that I've seen this demo, it really makes me want to delve into it in my next case. And hopefully others on this webinar will do the same. So thank you very much for that. We'll now move on to our last short video of Friends of Swiss Arbitration.
Hello everyone, I'm Hiroki Tezuka from Nishimura and Asahi Tokyo. It is my pleasure to have a few words on Swiss arbitration. I have always enjoyed my time in Switzerland, either on arbitration or other matters. Switzerland is known to be a neutral and accessible place or seat for arbitration, and Swiss arbitrators are considered very predictable and balanced. My experiences as a co-arbitrator or counsel with Swiss arbitrators also support such reputation. My Japanese client in a recent arbitration case in Zurich really loved his experiences there, and he told me that he would insist on Zurich arbitration in future contracts. But I had to tell him that Switzerland also has Geneva as an alternative place for arbitration. While Singapore is rapidly growing as a preferred seat of arbitration, there is a need for a neutral seat with strong civil law backgrounds, and I hope that Japan can learn a lot from the success of Switzerland, especially its efforts to improve arbitration facilities, update and modernize arbitration laws and rules, and promote arbitration in Switzerland.
I worked out of Zurich for 7 years. My first appointment as arbitrator was under the Swiss rules, working in Zurich. To my mind, there are essentially three main advantages to Swiss arbitration. First, you have as much administration as necessary, but not more. Second, you have extremely experienced practitioners, both as counsel and as arbitrator, who are dispute solution oriented. And third and finally, you have one court dealing with setting aside proceedings, the Bundesgericht.
For Lithuania, being a small country, the young democracy, it's always important to learn from those who are most experienced in international arbitration. To have experienced partner is always challenging yet rewarding. Challenging in a way, but we always feel that we have to step up and improve, and rewarding in a way, but we have possibility to ask best advice on a strategy on a case and rely on most respected arbitrators in the world. We are empowered by such partnership, which give us opportunity to have best results for our client. And this is all thanks to Swiss Arbitration Association.
So on behalf of everyone involved in the event today, I'd like to send warm thanks to all the friends of Swiss Arbitration who have provided their video contributions. I think it's fair to say that Swiss Arbitration really does have friends around the world. I will now hand over the floor to the President of the Arbitration Court, Xavier Favre-Buhl, and also, again, to Corinna von Trotta for their concluding remarks.
Thank you, Tanya. The test one should apply to assess where we are today is, first, is our arbitration institution solid and reliable? And two, are we applying efficient rules of arbitration? And the answers are yes and yes. This is why I am thrilled and proud of what we can offer in 2021. Let me try to deal with the 2 years in turn in the form of takeaway at the end of this launch event. Yes, we have a strong institution. When I started practicing arbitration in the 90s, ASA had ideas, Pierre Tarcier and others were close to bring an innovative project, but the time had not yet arrived. The initiative of creating one arbitration institution came from 6 Swiss chambers of commerce, joined by others later. And the Swiss chambers managed to unify their respective rules and work together for promoting arbitration in Switzerland. We should be very grateful to the chambers and acknowledge the significant efforts made to set up the Swiss Chambers Arbitration Institution SCAI and bring us where we are. Yet the Swiss dream had, at the time, one potential flaw: not working together with our friends of the Swiss Arbitration Association, ASA. Such a prominent body created and run by outstanding practitioners. We conducted separate activities. Something was clearly missing in terms of synergies. And Félix Dasser came. He and his fellow colleagues were courageous enough to imagine and propose a new innovative 5-pillar strategy for ASA, encompassing a new sky, no longer in the form of a Swiss association, but as a company limited by shares owned by ASA and the chambers. Swiss arbitration is a great idea, a terrific no-limit umbrella concept, which from now on enables to offer an array of services, including the administration of arbitrations. So thank you to our first panel, Gabrielle Natterbas, Pierre Tarcier, Anna Maria Taminen as moderator, for sharing with us what can be said about the past, present, and future of Swiss arbitration. Pierre emphasized the key role played by the Swiss law on arbitration, the tradition of arbitrations seated in Switzerland with highly experienced arbitrators, as well as Swiss judges and their high-quality decisions. Gabrielle stressed the Swiss neutrality, culture, and a number of tools that we provide. And the panelists agreed there is no fight between Geneva, Zurich, Lugano, and the like. A Swiss arbitration seat is good by definition. For the new generation, please keep in mind Pierre's 3H rule: head, hands, and heart. What strikes me as a great advantage today is that the Swiss Arbitration Centre is not alone. We have bridges with mediation, task as an appointing authority, and as a financial ombudsman. Young practitioners can build skills at the Swiss Arbitration Academy. The hub offers hearing facilities and other services. And the ASA Toolbox is an amazing device for counsel and arbitrators alike. I'm sure, as I did, you learned a lot listening to our third panel, Misha Chandna, Stephanie Pfisterer. Thank you for the great live demonstration, and Elliot Geisinger as moderator. This is simply unique on the arbitration market, ladies and gentlemen. Now, in my capacity as president of the Arbitration Court, there are two requirements for everything we have built to stand and for our institution to remain credible. Full continuity from Sky to the Swiss Arbitration Centre, and independence. Everybody can be reassured these requirements are entirely met. Full continuity is ensured. Arbitration clauses referring to Sky remain valid and binding. They are recognized and applied by the Centre as legal successor of Sky. We have registered our first cases since the 1st of June. The system works. Independence is also fully guaranteed. We keep an arbitration court assisted by a permanent secretariat. The board of directors of the company, the Centre Limited, is separate. There is no involvement, nor any interference in the court's work and decisions. The court is currently composed of 25 seasoned arbitration practitioners based in and outside Switzerland. It is fair to say that our arbitrations are often faster than those of other institutions due to the quick constitution of the tribunal, no need for terms of reference, no award scrutiny, etc. That was said by our speakers earlier today. My conclusion about the future of the institution is very positive when I look at Sky's legacy in terms of global exposure and trends. 90% of our cases are international. Around 70% of the parties are non-Swiss, from more than 120 different countries. The overall average duration of our cases, if you take all procedures, is around 12 months only. And gender diversity is ensured with some 70% of female arbitrators appointed last year. We have many ideas and projects to further improve the institution and its functioning and to be innovative. We are preparing rules for corporate disputes, a practice note for users, and other developments. Stay tuned. Last but not least, on the institution, a fundamental takeaway: please no longer use the word SCI, and do not call the center SAC or SAC. We are the Swiss Arbitration Centre, the center, no acronyms. Now, turning briefly to the Swiss rules, yes, they are efficient. They are chosen by users because of the trust in the system and its stability. We build on our experience, and that will not and should not change. The 2021 revision was not intended to be a disrupting revolution. It is only about consolidating and refining. Why? As that was recorded by our speakers in the previous panel, because for more than 17 years since the original rules of 2004, we have offered successful tools not requiring substantial adjustment, such as the very efficient expedited procedure. 40% of our cases are successfully handled through this accelerated procedure. Since 2012, an emergency relief procedure has also been available for urgent interim measures. That was mentioned as well. Now, with the outstanding presentation of our second panel, Jean Marguerin, Andrea Meyer, Almut Fordran, bringing the user's view and experience, and Corinna von Trottin as moderator, you heard about the main features of the 2021 amendments, and in particular, paperless filings, if desired, improved processes at various levels for increased speed and efficiency, reinforced requirements for independence and impartiality of arbitrators, modern conduct of proceedings, including with remote hearings when needed, awareness of data protection, cybersecurity, and a solid framework for multi-party and multi-contract situations, with the additional test in the new Article 5 about whether the arbitration agreements are manifestly incompatible, and the new Article 6 enhancing the former Article 2 to cover joinder and intervention of third parties, as well as cross-claims between respondents. All these issues are, in our view, important for users, and our role is to propose adequate rules matching the needs of modern practice. As Jean Marguerin underlines, our must was to keep this trust in arbitrators and their autonomy. This is a very important feature of the Swiss rules due to the ancestral-based origin of those rules. That being said, we all know the current trends, fully justified, for more transparency and reinforced supervision of the proceedings to ensure proper administration of all types of cases, including the most complex ones. This is what the 2021 revision brings, as you heard, with the Secretariat being more involved with cost deposits, the award being notified by them, and all communications being copied to the Secretariat. Now, ladies and gentlemen, beyond that, substance and procedure are in the hands of the arbitrators. I'm not sure that the role of a court is to interfere with a tribunal's work. Stepping in may not be appropriate when the proceedings are properly handled by arbitrators precisely appointed to make an award. When a tribunal has been constituted, the right place of our court and the Secretariat now and in the future is to watch, advise, be available for helping the parties and arbitrators, rather than appearing as happy to exercise policy powers and impose sanctions. We are fully aware of time requirements and cost concerns, and we will always be strict in case of problems and abuses. But our experience shows that the Swiss rules and the arbitrations conducted under those rules proceed smoothly, and feedbacks from users are excellent. We are convinced that a wise case-by-case approach is more suitable than applying strict, uniform standards to all matters, whatever they are. We have no doubt that our revised rules will enable us to keep and even increase the high level of quality, efficiency, and reliability that we have offered so far. Please do consider using the Swiss rules for your future arbitrations and the services proposed by the Swiss Arbitration Centre. This is really worth it, I promise. Thank you.
This has been 2 hours filled with the new offerings with respect to alternative dispute resolution from Switzerland. We hope that this looks as solid as the Swiss mountains, as practical as a Swiss knife, and as addictive as Swiss chocolate. You have now heard from Felix about the new umbrella brand, Swiss Arbitration. You followed Gabrielle and Pierre through the past, present, and future of Switzerland as an important center for international arbitration. We highlighted the key features of the revised Swiss rules, and we introduced the Arbitration Toolbox by ASA. And in a few moments, you will have the chance of chatting in small breakout rooms about your views on all of these developments. What you have not heard and seen in the past 2 hours, but what you may imagine, there have been many more people involved in all of these projects, which do not have the chance of, or who did not have the chance of speaking to you today. All of them have worked tirelessly until this very moment. So on behalf of ASA and the Swiss Arbitration Centre, I would like to thank all of them from the bottom of my heart for your tremendous efforts and all your dedication during the last year. With all of your ideas, your guidance, and your support, we paved the way for Switzerland to become an even more successful place of international dispute resolution. At this point, I would like to pass over to our audience, our friends in Switzerland and all around the world, to spread the word about Swiss arbitration and all it has to offer. Thank you.
For my part, it's now time to say thank you to all of you who have joined us for this exceptional launch event. I must say that I hope that in a future conference, in the not too distant future, we will be able to interact during a break over a cup of coffee or perhaps a glass of wine. But until that time, we hope you've enjoyed this remote conference. Now, before we conclude, I'd like to pass the baton to Chris Boog, who chaired the organizing committee of the Swiss Arbitration launch event, and he'll close us off with a few words. Over to you, Chris.
Thank you very much, Tanya, and hello everyone also on my part. On behalf of the launch event organizing committee, I'd first like to thank all of the panelists of today's conference for their truly excellent presentations, and of course, all of you participants for taking the time out of your busy schedule to attend today's event and support Swiss arbitration. We hope you enjoyed the studio setup for today. Nevertheless, of course, we do hope to see you again in person next time round. We will be organizing further conferences and workshops to explore in more detail some of the topics addressed today, including regional events and events geared towards specific industry sectors. These future events should answer any questions you may have in relation to Swiss arbitration, the new Swiss rules, or the Arbitration Toolbox by ASA. We will be announcing the dates of these events on our website in due course, so please stay tuned. I'd also like to warmly thank the members of ASA and the Swiss Arbitration Centre, as well as the launch event organizing committee, without whom this event would not have been possible. A very special thanks goes to Delphine Vielieu, ASA's marketing manager, for her hard work in the weeks leading up to this event. So we will now open up our virtual networking event. There will be 2 15-minute networking sessions. For each, you will automatically be allocated to a different breakout room, which will be moderated by members of the Swiss Arbitration Centre, Court, ASA Executive Committee, as well as the ASA Board. To join the networking session, you will have to leave this Zoom webinar and join a new Zoom call. You can do that by clicking on the Zoom link that is available in the chat function on your screen. It was posted, I believe, at 5:43 p.m. You should be able to simply click on that link and then follow the instructions, and you should be asked to leave this webinar and join the new Zoom meeting. In case that does not work, a new Zoom link has also been sent to you by email a few moments ago, so you can simply leave this webinar and start a new Zoom call by clicking on the link in the email you received. We look forward to seeing as many of you as possible in that session, and thank you for joining us today. So now please follow me and join me on the networking platform by clicking in the link or in the email you received, and see you there in a minute. Thank you very much, everyone, and see you soon.